Good morning, and thanks for joining us for today's webinar, New Competition Act Requirements for Employers, What You Need to Know. While I introduce myself and our speakers, please see the information slide that is on your screen. We really appreciate you taking the time to complete the survey. Your feedback is very important to us, and it allows us to improve our programming. So please take a moment to do that if you can. With respect to questions, we will address questions we have already received throughout the presentation, and we'll have an opportunity at the end of the presentation to answer some further questions. So please use the questions tab. My name is Alix. I'm a senior partner in the Labor, Employment and Human Rights practice group in the Fasken's Toronto office. And within my practice, I obviously pride myself on providing practical and solution-oriented advice to my clients. It's my pleasure to introduce my fellow panelists for today. Tony Domenico is the co-leader of Fasken's Competition, Marketing and Foreign Investment Group. And he served as counsel at the Canada's Commissioner of Competition. So of course, we're eager to hear his thoughts on what the Competition Bureau thinks about these new provisions. And he's served as counsel in many of Canada's most significant competition matters. He's also recognized widely as one of Canada's leading practitioners in competition law and litigation. So we think his advice today is going to be invaluable for our clients. My fellow panelists and in my department is Marc Rodrigue, who's a partner in our Labor and Employment Human Rights group here with me in Toronto. And he obviously practices in all areas of employment, labor, and human rights, with a special expertise in labor arbitrations and in litigation matters before all the courts and tribunals and the Ontario Labor Relations Board. So let's turn to our presentation today. So we are here to talk about what these new provisions in the new competition provisions actually mean. And these significant amendments are coming into force on June 23rd, so not far from today. And these amendments will apply across Canada. And they will prohibit wage fixing and no poaching agreements between employers, whether they are competitors or not. And these no poaching agreements, in which two employers agree not to solicit each other as employees, could constitute criminal activity and be subject to severe penalties. We'll also hear about what wage fixing means, and this encompasses more than just what we hear when we hear the term wage fixing. And Tony will explain the broadness of this new legislation and best practices around it. So we obviously believe that employers should make themselves aware of these new responsibilities and restrictions under the Competition Act and review their current practices to ensure compliance with these new provisions. In terms of what we're going to deal with today during our agenda, we're going to look at what are no poaching and wage fixing agreements, how do they work, what are the potential exemptions and statutory defenses that are available to employers. We will also address the penalties for breaching these new provisions, situations that are not covered by the legislative amendments as currently interpreted by the Competition Bureau. We're going to do a quick refresher on non-compete agreements between an employee and employees, in particular in Ontario, and best practices to be implemented by employers with these new provisions in mind. So I'm now going to turn it over to my partner, Tony, who will explain these new provisions.
So thank you very much, Alix, for the warm welcome, and it's a pleasure to be with you today. As Alix had noted, I've been with Fasken my entire career, but I did take a leave of absence for a few years to be counsel to the Competition Bureau. So the comments I'll be making today have regard to not only my experience in private practice and helping clients navigate the Competition Act, but also the perspective of the Competition Bureau, and probably a little bit of context for what led to these amendments and also how to work with them and to navigate any potential pitfalls that may be arising in the future. So maybe we can take a step forward and moving to the next slide and talk a bit about what are we actually talking about here. So in about less than a month now, the criminal conspiracy offenses under the Competition Act will include a new prohibition that is focused on what I would characterize as sort of two things, so-called wage fixing, and the other being so-called no poach agreements between unaffiliated employers. We'll get into the unaffiliated employers bit in a moment, but just to characterize what we're talking about, and this is taken right from the legislation. Wage fixing pertains to agreements between these unaffiliated employers to either fix, maintain, decrease, or control salaries, wages, or terms and conditions of employment. We'll break that down later on in the presentation, but what this effectively means is an agreement between these unaffiliated employers to effectively fix or predetermine what a wage, salary, or term of employment may be for employees. No poach agreements refers to an agreement, again, between unaffiliated employers not to solicit or hire each other's employees. These effectively represent non-solicitation type provisions that you're all very used to. And we'll get into what this amounts to at a practical level later on, but just to forecast what the Competition Bureau is really focused on is sort of these two-way no poach agreements where you agree not to solicit each other's people and less focus on the one way. But again, we'll get into that in a moment. So what makes this provision a bit unusual in a competition context is that competition legislation is normally focused on competitors and what competitors and agreements between competitors to do or not do things. You would have heard that we've had for many, many years around the world, including in Canada, prohibitions against price fixing between competitors, which is not uncommon. And so training like the one you're receiving today is very common for your sales colleagues, I'm sure, who are reminded not to contravene the Competition Act. What's unusual about this legislation is that it's just not restricted to competitors per se. And you can, in theory, have a scenario where you have a company, you may envision an agreement between yourself and another company that you don't compete with. But if that agreement amounts to wage fixing or no poach agreements, that can represent a contravention of the legislation. So if you move on to the next slide, you'll see that the breadth of this statute is sufficient enough to warrant scrutiny. So, employers don't need to be competitors. It's enough that they're just not legal affiliates with each other. And it doesn't even matter if you're agreeing or not to agree on whatever the job category may be or not be. So a restaurant and a dry cleaner can agree to fix the starting wage of an employee, or perhaps not to solicit each other's employees. That probably wouldn't happen as a practical matter, but technically speaking, that's the breadth of the legislation and what it's focused on. And just for a little bit of context, Canada isn't unique in this implementing such legislation. I would say beginning in about 2015, competition legislation around the world has seen labor being a focus. Normally, what competition legislation is focused on is ensuring that prices for products and services are not above competitive levels, and ensuring that companies are incentivized to produce innovative products and services for customers. Labor has traditionally not been a focus for competition enforcement. But there's been a recognition among many competition authorities around the world that standards of living are sort of premised upon good working conditions. And there was a concern that wages were being suppressed or terms or conditions of employment were being suppressed as a result of companies sort of formally or informally colluding to not increase wage and terms of employment circumstances, or with implicit agreements not to poach each other's employees. This was seen as sort of lowering conditions for employees they otherwise could get if there was vigorous competition. And so we saw this movement begin in the United States back in 2015 with guidelines from the agencies there, the Federal Trade Commission and the US Department of Justice. And you're now starting to see this around the world, not only in Canada, but in Europe. So this isn't an isolated thing for Canada. It's actually something that's growing in importance, but it's not without controversy because it's very difficult to navigate and monitor how employment conditions factor into competition between entities in where the focus normally is on product choices and lower prices for consumers. But that's just a bit of a digression, but you should just know that this is sort of the legislative underpinning for why this is going on. To going to the next slide, you'll see that what are examples of wage fixing agreements? Well, these are agreements between, with another company that sets salaries or bonuses at a certain level or within a range. Agreeing with a competitor, say, not to increase salaries or to increase salaries at a certain percentage per se, or agreeing on other terms of compensation or terms and conditions of employment. We're going to get this get there in a bit, but the Competition Bureau has released some draft guidelines that talk a bit about terms and conditions of employment. We're going to investigate a little bit what the scope of that may be. Moving on to the next slide. No poach agreements really amount to, promises between companies not to compete for each other's employees. So they can be written and oral. They can be inferred by the surrounding circumstances. What's important here is that rarely in my career, I could say never in my career have I ever seen a price fixing arrangement memorialized by way of a formal agreement, right? When you see something like that, it's normally very covert to begin with. And I think as a consequence, the Competition Act actually has embedded in it the capability of capturing not only written but oral agreements, and even ones that can be proven through circumstantial evidence. So just be aware that any sort of wink, wink, hush, hush, or sort of meeting of the minds can't be captured. And that's why we take compliance in this area very seriously. Now, the agreements, and this applies not only to no poach, but to wage fixing, can exist, again, the context is sort of a standalone or naked agreement, as they call it. But more often than not, such provisions are contained in other agreements. So you can have a very traditional transaction agreement where someone's buying a business that contains a non-solicitation provision in it, right? Or you can have an NDA or a settlement agreement resolving disputes that contain such clauses. And so it's important to be mindful that those kinds of things can exist as well in the context of other agreements. So moving on to the next slide. Now, I don't want to get too bogged down in legal defenses, but we should just be mindful that there are sort of legal defenses that can be raised here. The obvious one being if you're affiliated companies, a parent and a sub, something like that, that's not going to be captured here. Regulated conduct, jumping to the third, is actually a very complicated defense, I can tell you, involving whether or not your contravention on competition or the impugned conduct is actually authorized by other legislation. We can get into that another day. That's why we have the LCBO, for example, and other fun things in this province. So again, another day, and happy to chat about it. Ancillary restraints defense, though, is one that are actually more applied to these circumstances. And that's where the restraint on competition can be ancillary to a broader or separate agreement, and it's directly related to and reasonably necessary to give effect to that. So traditional example is if you're buying a business, and you would want some form of a non-solicitation of the key employees of that business. Otherwise, why would you agree to sell that business? So you can see in that context why some sort of restriction on competition or non-solicitation can be important. Again, this is a very finicky defense, and it's a defense. It's not a complete get out of jail card, but it's one that can be relied upon in the right circumstances. We often work with clients to try to help them bootstrap this defense as much as possible and make sure it's memorialized in their ordinary course business document. So there's something real to it that can be relied upon. Moving on to the next slide. Penalties are significant, folks. And that's why we're taking this very seriously. It's a criminal offense. And so the breaches can lead to, fines in an amount that can be in the millions of dollars in my experience. The act actually does not set out a limit, and technically jail time. It's rare for people to go to jail with a toothbrush, as we say. That's the test we apply in Canada, but it's happening more and more, and it's something that we really want to take seriously as a result. The other piece of risk here that I think we need to be mindful of is the private rights of action, and in particular class actions. Enforcers, and I've been at one, have residual discretion to really focus on what is hardcore cartel activity, and probably distinguish things that may be technical and not really in their interest. But I wouldn't say that's the case for private litigation, where a private litigant can commence litigation for even a technical breach if they think that there's a basis for it and also a basis to recuperate significant damages as a result. So that's why we really want to be mindful of not only the public risk, but the private enforcement risk that can arise from this. Moving on to the next slide. So I just want to spend a few minutes just talking a little bit about the draft normative guidelines. Now, the Bureau came out with draft guidance and we're expecting new guidance anytime now. In fact, I have a hunch that we're going to get it today based on a session that the Commissioner of Competition gave last week. So if it comes in today, I'll try to read it quickly to interpret it. But my experience, the draft guidelines and the final guidelines don't differ all that much. So I think what I'm going to be talking to you about in any event will apply here. So moving on to the next slide. I was talking to you a bit about these two-way and no-way, one-way provisions. So the Competition Bureau sort of clarified that the no poach will offense in its mind applies only where the unaffiliated employees agree not to poach each other's employees, and each other comes from the legislation. So as a matter of statutory interpretation and the Bureau's guidance, I think we can take significant comfort that one-way provision should be fine. Now, again, a class action litigant may disagree and decide to commence its own proceeding. So I think we still want to be mindful of the one-ways and just think about risk mitigation steps. But it's really the focus here is on the two-way provisions that I think are really ones that we should be focusing on to make sure they're either not there, or if they are there, there's a basis upon which we can legitimately include them there, relying on a statutory defense. Moving to the next provision, the Bureau also made clear that non-solicitation clauses M&A agreements, which caused a lot of anxiety out there when this legislation was released, is not really the focus for the criminal provisions. It still can be reviewed under civil provisions. And of course, the Bureau does give itself wiggle room for exceptions. But really, the non-solicitation M&A context is not really what the focus, I would say, of these criminal provisions are looking at. So I think that's another piece of comfort we can take from this. Moving on to the next slide. The franchisor-franchisee context actually does give us a fair bit of heartburn, because the provisions, I would say, respectfully, don't take into account the franchisor-franchisee context as much as they could. Because as you know, franchisors and franchisees frequently are not legal affiliates. That's sort of the very basis of their legal relationship. But given that unique relationship, it can be very much in line and in the interest of all parties for a franchisor to sort of expect certain standards to be applied in the context of the employment of employees at the various franchisees. And so there's a lot of concern about how these provisions will be applied in that context. I'm expecting a bit more guidance in these finalized guidelines that are going to be released anytime now. But as far as we know at this point, what we need to keep in mind is that any sort of arrangement between the franchisor and franchisee can be applied to this context, and also the sharing of information between them is something we just want to pay attention to. We would see here the application of the ancillary restraints defense as sort of important in this context, and we've been working with a lot of clients to try to facilitate the use of that defense in that franchisor-franchisee relationship. But it's one thing that we're getting a lot of calls about and we're mindful of, given the unique relationship that a franchisor has with its franchisees. Moving on to the next slide. In terms of employment, I mentioned this to you earlier that the Bureau had released guidelines about it. And I would say that, again, this is a bit lacking too. There could probably perhaps be a bit more detail here. But what the Bureau says on one hand is the terms and conditions can include a lot of things. And they give a long list that's contained on the slide there. However, they say that, what they're really focused on are things that affect a person's decision to enter into or remain in an employment contract. Now, I'm only the competition lawyer. I really defer to the labor and employment experts on the line here for what that may be. And I think it's a matter of some discretion. What the Bureau is getting at, though, is that something that can maybe seem peripheral to a decision to remain employed or be employed with a company is not what they're focused on. But, working remotely or versus being in person, is that sort of a key point? You probably tell me yes these days, but it's a real debatable point. But when the Bureau brings up mileage reimbursement, I wouldn't have thought that's a big deal, but maybe it can be. But so this is something that I think that you want to continually talk about. But the takeaway is, in terms of industry practice and your own companies, what is actually a salient term of employment or not? And that's sort of the decision making you want to be keeping in mind for such provisions. So I've done a lot of talking. I'm going to pause there and give it over to my colleague, Marc Rodrigue.
Yeah, thanks, Tony. I'm glad to take a quick sideways step here for a lot of folks who heard that these new Competition Act provisions were coming in. And immediately, I know, feeling the fatigue of the last few years and the multiple changes that you've had to make to your workforces or your employment agreements, a lot of you immediately thought, uh-oh, are there going to be new issues for me in my employment agreements directly with employees? So leaving aside agreements between employers and organizations, let's take a quick look again at where we're at with non-competition provisions directly with employees. I think for the most part, what we anticipate is that there's unlikely to be much of an impact here, but I say that with a caveat. Of course, as Tony said, sometimes agreements that the Competition Bureau might be looking for are not so expressed between people. But if employers have agreements between each other's and they stick non-competition provisions into their employment contracts and agree to do that and name each other, for example, well, that might be a problem down the line. But I think for the most part, absent getting together and deciding to do that, we're stuck with what has been long the case for non-competition provisions in employment agreements. When you sign an employee to one, they are used and enforceable in very specific scenarios. Generally speaking, the courts do not like to see them or enforce them as a restraint on employees being able to earn a living. And we have seen, at least in one jurisdiction in Ontario, and I'll speak to that immediately on the next slide, please. In Ontario, you've seen, again, the government step in and create even more restraint recently on the use of non-competition provisions with employees. I know it won't be new for many folks here, although we haven't run into it too many times on an enforcement side, that since October of 2021, we are not permitted to sign employees to post-employment non-competition provisions unless one of two specific scenarios are involved. One is the sale of a business where we have purchased someone's business, they're coming over and being an employee with us. And of course, as part of that sale, we want to bind them to a period of non-competition should they leave. Otherwise, again, the sale would make no sense, although there are going to be some nuances in that and the way the legislation has been written that we want to pay particular attention to if we're going to rely on that exemption. And the second one is certain defined, essentially executive employees who at the C-suite of the company, we of course want to bind to a period of non-competition should they leave. Even though I will say one of these exemptions may apply in a certain scenario, the general principles about how difficult it can be at times to enforce non-competition provisions can still apply at the same time. So we got to make sure still, even if we hit one of these exemptions, that we are carefully crafting these non-competition provisions. On to the next slide. Again, on your slide right now, you'll see the definitions from the legislation. This is, again, is in Ontario, and I'll caveat to say that Ontario tends to be the leader in developing new employment standards legislation that other provinces will look to from time to time, or the federal government. So you may see these definitions start to appear elsewhere at a certain point. And again, this is the two exemptions that we have where the government has said we can still have non-competition provisions in our employment contracts. On to the next slide, please. We haven't seen too much, as I said, enforcement on these provisions. The one major case we saw very early on involved the sale of a business, essentially. And that sale had happened well prior to the coming into force of the legislation in October of 2021, where the person who sold the business joined it, a dental agency, joined the business afterwards and worked for a period and then quit. And his non-competition provision said that he could not compete within 5 kilometers. And so naturally, of course, he went ahead and did that. Once the new legislation came into effect, one of the defenses he put up against an injunction trying to get an interim stop to that competition, being competing as a dentist nearby, was to say that the new legislation had essentially eliminated his non-competition provision, which again had been enforced since before the legislation. The court has given us some guidelines on this, saying no, this only applies to new non-competition provisions entered into after October 25th, 2021. But so if you have non-competition provisions in your agreements, in your employment agreements predating that, you should be fine, subject to the caveat that they're enforceable in the first place. But we're still waiting to see whether or not there'll be some more action on this front. As we've said, we haven't seen much yet. It's still a fairly new provision. And it certainly isn't one that we've seen the Ministry of Labour in Ontario spend a lot of time on, but every summer, every year, they refresh what they're going to look at, and it could be that they finally get around to these provisions. On to the next, please. Now, again, there are certain restraints that we can put on employees post-employment that are still effective tools in the toolkit, so to speak. So even though non-competition provisions may be difficult for us to have, regardless of the jurisdiction we're in right now with our employees, confidentiality provisions can be key. Certain industries, your employment agreements are worth nothing in certain industries unless you've addressed that. So make sure that we're well written in protecting our intellectual property and our confidential information. The same thing with non-solicitation provisions. Again, these have to be drafted in a certain way, making sure we're ticking certain boxes. I always suggest, there's some good lawyers I know that can help you with that. But we want to make sure that we're doing it clearly and doing our best to protect against the solicitation of our employees, our clients, our suppliers, our vendors, when somebody leaves the business for a reasonable period of time. And that may be different and needs to be tailored based on the certain employee or employee subset that we're dealing with. But these remain and are untouched. With an asterisk, there may be scenarios, but with an asterisk by these new Competition Act provisions. Next slide, please. Just some key takeaways again. So I know that in the immediate aftermath of the announcement of the Competition Act changes and new provisions, I know I certainly got a lot of calls about folks worried about their agreements directly with employees. Again, for the most part, that there may be very little in terms of impact, and we're dealing with the status quo, which is to say non-competition provisions are going to be difficult to deal with. And in Ontario, we have to deal with legislation already that will knock most of them out. But other post-employment restrictive covenants, again, confidentiality, non-solicitation, other ways to protect the business are status quo and tools that remain in the toolkit. And with that, I will pass it over to my colleague, Alix.
Thanks, Marc. So if we move to the next slide, the basic parameters that Tony has discussed with us today is that there should be no agreements with other employers with respect to hiring each other's employees or wages, and as we've seen, this broad concept of any terms of employment. So a couple questions have come through which are indicating, can we still enter into non-solicitation agreements with our employees? And we're saying yes. Yeah, we're talking really between agreements between employers, and as Tony said, even if they're not competitors. So that doesn't prevent us from actually entering into one-sided non-solicitation agreements. And in Ontario, you can have non-compete agreements during employment, just as we've discussed with Marc, not following the employment relationship. And so for those of you who are concerned about whether you can do that, yes, you can continue to do that, subject, of course, to what Marc has said, is that the courts will look at the broadness of those non-solicitations. And we've obviously seen through the case law tightening up of those provisions so that they're not so broad that you can't solicit any client of the company. It has to be related to those clients that employee would have material contact with. So again, making sure that the scope and duration of your non-solicitation provisions are reasonable in the court's views. The second thing, obviously, that's very important is, discussing or exchanging information with other employers on items in terms of employment and not hiring each other. And so, when you think about informal discussions that you have at industry events or HR professional type events, those are the type of situations that you could infer that there was an arrangement in place. And Tony and I will talk about that later on in the presentation. But I did want to just sort of mention, because, a question did come through about whether or not, as a public sector employee, the disclosure of information. So, we generally recommend that you don't discuss or exchange information with other employees regarding terms of employment, especially compensation terms. But as we know, all other terms like allowances, mileage, bonuses, whether you use restrictive covenants at all, etc. But when we talk about benchmarking data and publicly required information, we consider that a safe space of exchange of information. And we'll deal with that in a little more detail towards the end of the presentation. But if we move to the next slide, this is a reminder again about all the terms, and that could include leave policies, allowances, perquisites that you give to your employees, things that would incentivize employees to enter into those employment agreements. And so we want to make sure when you're talking sort of generally like, hey, how do you disclose, how do you pay your, frontline employees this way? Or, how are you dealing with your management employees or your field service employees? You want to be careful that in that exchange of information, you're not implicitly inferring that you should have some agreement to kind of keep the marketplace, down or equal, so that you don't have these sort of inferred agreements or arrangements in place. A couple questions that have come up, Tony, that I thought we could just answer right now before we move on is, whether we could have these no poach agreements embedded in existing, MSAs or NDAs. Is there a need to amend those agreements? And I would say no. I mean, I think that's what they're sort of saying in terms of that ancillary defense. But could you give us a little bit more context of this question?
Yeah. So the compliance part of it actually has a few different answers. And so let's just assume that there is a provision that you're uncomfortable with. Okay, like just park the ancillary restraints defense for now, but let's say there's a provision you don't want in there. How do you deal with it? Because sometimes you don't want to reopen an old agreement with another party for all sorts of other reasons. So, the official way could be to reopen that agreement and amend it and strike that term. What we've also seen is simply one party writing to the other and saying, listen, we're not going to enforce this portion of the agreement. And since a conspiracy by its very nature requires two to tango, as they say, that does give some comfort altogether. And sometimes even lighter option than that is just to internally say, I'm not going to, and memorialize that, comply with this provision. I've seen less that. So of the three options, I've seen the second one being the one that's most popular, where you simply just write to the other side and say, we're not enforcing this non-solicit, or whatever the case may be.
Thanks, Tony. Another quick question is, what about IT service agreements? These obviously have lots of non-solicitation or no poach agreements within those. How would you respond with respect to these provisions?
Again, what I would say is take a step back. Is this an agreement between two unaffiliated employers, right? So as Alix has pointed out, if it's employer and employee, that's not what this is designed to deal with. So this is about two employers.
Yeah. Let's assume that it's an IT company that's providing IT services to another unaffiliated company. As part of that agreement, they don't want the company to solicit their IT, experts to go and work for the company.
Right. So again, if that, in that context, in that example, if it's a one-way non-solicitation, you should take comfort in that, because for two reasons. The legislation says agreements with each other, and the Competition Bureau in its draft guidelines, subject to seeing their final ones, but I don't expect them to deviate from that, saying that they're only focused on one way. Again, there's a I would characterize a remote possibility that a class action litigant or a private right of action will be commenced on the basis of a one way. But I would say, in terms of if you ask me my own risk tolerance, I'd be comfortable with the one ways, just having regard to the factors we just outlined.
Great, thanks, Tony. A couple other questions have also come out about what do we mean by affiliated entities, and are there any controls that you need to meet? Or is it simply the fact that you are related employers or affiliated employers sufficient to get you out of these provisions?
So affiliation, and I'm happy to speak offline with anyone who wants the detail, but you have to go with the definition of affiliation in the Competition Act. And in Section 2 of the Competition Act, there's a definition of affiliation and a definition of control, which is pretty broad. What we're effectively talking about here are legally controlled entities where you have a company that may be legally affiliated with someone else based on a control test. That's usually based on the number of securities someone may own in the entity, sort of an equity-based model. So I would characterize it as a pretty broad control-based test that is not too dissimilar from what you would characterize as a control or legal affiliate relationship.
Great, thanks, Tony. So if we move over to the next slide, you know, what we've seen throughout this presentation, right, is that there is a broadness to this legislation because of the fact that if you're unaffiliated companies that are interacting with each other with respect to how you deal with your labor and your employees, you need to be really careful about the types of information you're sharing. And so a number of the questions that I've seen come up through the presentation is, you know, what would constitute sort of the exchange of information that the Bureau could then interpret as being an inferred arrangement or agreement between two employers or more. So, you know, what Tony and Marc and I have discussed leading up to this presentation is that, you know, the idea of benchmarking data and how you use benchmarking data is really important. And I've seen a number of questions around that. And benchmarking data by a neutral third party that anonymizes that data can be used, right? Where you want to be careful is what, you know, which benchmarking data are you using? How is it being compiled? What details are within that data and whether or not you can implicitly rely on it. So Tony, do you have any further comments on that in terms of, you know, what you've seen at the Bureau in terms of benchmarking data?
Well, benchmarking services are by its very nature, as Alix pointed out, a third-party source of information. And so you often have benchmarking agencies that will collect information and will release industry trends that you can rely upon. And those industry trends are normally sufficiently anonymized and aggregated such that you can't reverse engineer who's really who. That forms the basis of that. So I think that is perfectly fine. What competition agencies get heartburn about is, one, if you can deduce things based on the information perhaps not being as aggregated or anonymized as it could be, because you may have 2 or 3 players in the industry, and so you can pretty much figure it out. So that's what gives them heartburn. And also just making sure that there isn't some form of, this is my competition terminology, hub and spoke conspiracy, where really it's the agency is sort of used as a tool by which to otherwise engage in a conspiracy. That's what they're stressed about. And so you want to make sure that whatever arrangements you have with the agency, of course, you're not engaging in hardcore cartel activity, but you want to make sure that the agency actually has an agreement between yourself and that agency, some sort of provision that provides that they comply with applicable laws, which would include the Competition Act. And in fact, we're expecting such agencies to have a more prominent role now, having regard to these provisions. And so I don't think that's going to come to a surprise to them. And I think everyone is incentivized to ensure that they don't do something that could be perceived to be contrary to the law.
So, you know, that leads me to the next point, which is there's a real subtlety to the way this legislation can be utilized. And so, you know, just as Tony mentioned at the beginning of the presentation, when we look at like sales and pricing teams and ensuring that those teams understand their obligations under the Competition Act, it is going to be important for employers to think about who's in their recruitment staff, who's in their, you know, HR staff, how are they interacting with other recruiters in the industry, and ensuring that these inadvertent sort of discussions don't lead to some sort of, you know, breach of these provisions. And so obviously Tony's already, in light of this provisions coming in, Tony's already started training to encompass some of these obligations to really bring to the forefront thinking that needs to go into place when your HR staffer is out sort of, interacting in the community, so to speak, and at industry type events and HR events. So really important to kind of think of a compliance aspect for this as we move towards the legislation coming into force. I'll turn it over to Tony at this point on the next slide.
So I should just mention, I just saw an email come out that the finalized guidelines from the Competition Bureau are out. I don't think I can quite read and present at the same time, but I will try. And if I see something noteworthy, I'll mention it during the balance of the presentation. But I did want to flag that as coming out. So I think, as Alix has pointed out very well, the exchange of information is a very sensitive area. So let me just take a step back just so we can follow the logic. What is being prohibited in Canada is the agreement between the unaffiliated employers to do these bad things, wage fix and engage in no-poach arrangements. The exchange of information in Canada is not an offense. It can be in other jurisdictions, but in Canada, it's not the offense. But the reason we're concerned about, and the reason it gives significant heartburn for regulators, is that the exchange of confidentially sensitive information, and in this context being wage, benefits, or terms of employment related, can be seen as facilitating an agreement to do the quote unquote bad things. And so you may not have an agreement with a competitor to fix wages, but if you're sharing your salary information between each other, that can be used to enter into those agreements, even without memorializing such an agreement. So through circumstantial evidence, the Bureau can make inferences about that. And that's why it's very important to ensure that you're not exchanging such information with each other and with other companies, so as to not be seen to be doing these bad things. Now, when we talk about guidance for the Competition Bureau, you have to assume when you're writing your emails and engaging in your messaging, whether it be in writing or orally, that the Bureau will receive your documents one day. Now, why am I saying that? I'm not saying the Competition Bureau is going to come raid your office. They could, if they have reasonable grounds to believe that you have something. But it's not so much the dawn raid or search warrant context that gives me heartburn. But what gives me heartburn is oftentimes the Bureau, through other ways, gets access to your documents. For example, if you are engaging in an acquisition of any kind that exceeds certain financial thresholds, that transaction has to be brought to the attention to the Competition Bureau. And that transaction could lead to information requests arising out of the ordinary course documents that make its way to the Bureau. And then with those documents in hand, if there is an email that suggests that there is in fact something that gives rise to concern with these provisions, it doesn't take much for the Competition Bureau, and I know this from experience, from the merger officer to walk up the stairs to the criminal office and say, hey, you should have a look at this. So there are lots of ways in the Bureau can get access to your documents, and you don't want someone without context reviewing your emails and saying, I really wonder what's going on here, even though it may be something completely innocuous. So if you just move on to the next slide, let me give you just some examples of this, right? So, under the heading employee rights, you'll see a set of quotes of what someone may write. It may seem completely innocuous. And then on the right is what the Bureau may interpret that to be, right? So there appears to be an industry consensus that retail workers' salaries will not rise. Well, that's a pretty innocuous statement. That's just someone's observation. The Bureau may see that as being competitors have agreed to some sort of price or salary increase, right? Avoid ruinous competition for talent. Someone may just be saying that, but that could be interpreted as stop competing. We need to bring stability to the marketplace. Stop competing. Let's stay in your market. We'll, let them stay in their market. We'll stay in ours. Competitors have allocated the market. So you can see how, fairly innocuous phrases can be perceived as being more than that. And so that's why through this training, you really want to be mindful of the language you're using and also encouraging your teams to be careful with their language, right? And, in the sales context, we've been giving presentations like this for decades. So your sales personnel are very well trained as to spot issues. But I have a lot of sympathy for HR professionals who probably are encountering this for the first time and are maybe very used to either communicating with other HR professionals at other companies, or are just not thinking through what kind of inferences can be made based on someone's statement in an email. And so that's what we're trying to help with you now, is to ensure that you're starting to see some of these potential pitfalls, and so that you don't have your correspondence scrutinized one day and leading to some form of inadvertent interpretations that an officer may have without context. Which leads to the last slide, which is compliance is good business. It's the right thing to do, of course. And I think you would all agree, no one wants to be engaging in conduct that would be contrary to the law. And so having a session like this is helpful in that regard. But I will tell you that, having helped clients over the years with investigations, that it's a very costly thing, not only with respect to the exposure, but with respect to the opportunity costs and reputational damage that arise. When you're spending a ton of time with company employees dealing with an investigation, that person's not doing their job that they otherwise would be doing. And that's a real drag on the opportunity cost of that person, what that person could be doing. And I just think it's a distraction overall to have to either defend an investigation or, litigation in this context. So it's something that I think can be prevented through good compliance. The fact that you've done the compliance training and that your organizations are, I would say, is important. In the unlikely event you ever got into trouble, one of the first questions the Bureau will ask you is, do you have a compliance program? So you really want to be able to check that box. But I would say, in addition to checking the box, it does a fair bit to avoid inadvertent things from happening in the future. So let me give it to Alix, who will implement the test that we have for you.
So we thought it might be helpful to do a few hypotheticals, a fun test of what we've learned today. So, feel free to jump in and give your opinion, showing us that, you're understanding what we've been saying today, and we'll, of course, provide some additional information. So the first hypothetical is we have 3 competitors. They're concerned about competition for talent, as many of our clients are, and they're all manufacturers with locations in Canada. The 3 competitors meet at an industry event and decide to have coffee together. And, as I've seen in some of the questions, what happens if it's, HR professionals at the HRPA, networking event, which often happens, and they decide to hourly enter into an agreement to cap their annual bonus for new hires. So, Tony, good, bad?
What do people think? Thumbs up, thumbs down?
Just jump on the chat.
This is a tough one. Not too much traffic on the chat as people are pondering.
So we obviously know that this is bad, right? Oral discussions count. Consensus between a bunch of different parties counts. As Tony said at the beginning, you're never going to see a conspiracy where they've written it in an agreement. It's going to be implied oral discussions for the most part, and it's always kind of cryptic, right? But as Tony mentioned, the Bureau will look at all the evidence before them. So Tony, if we said, because I've seen this in a couple of the questions, let's just say they're at that event and they randomly discuss sort of like expectations of talent for certain salaries, and these 3 individuals sort of say, well, generally speaking, we're trying not to increase our salaries, we're keeping it in a certain range. What do you think about that sort of disclosure to each other?
It gets a bit uncomfortable because you're starting to discuss parameters that can be used as a basis for an agreement. I think the takeaways, obviously, that Alix has outlined with respect to oral agreements are captured. But let me just give you one other contextual factor of why this is dangerous. The Competition Bureau has a leniency and immunity program. And so the way, cartel activity is very difficult to detect, given how covertly it's implemented. And so what the Competition Bureau has done, and agencies around the world have done, is to sort of to look at the prisoner's dilemma of psychological thinking, if you've ever read about that. And they thinking of ways in which to incentivize others to sort of rat on the other. And so if you are the first person to tell the Competition Bureau of an arrangement of this sort, you can qualify for full immunity, not only the organization, but all its officers, directors, and employees. But if you're second or third, you have to plead guilty but a reduced sentence, again, assuming you fulfill all the requirements of the program. If you don't do anything, and the Bureau is, as a result of the immunity applicant telling the Bureau all the details, which it's required to do as part of that, the Bureau will then have a blueprint by which to then raid you and charge you for the circumstances arising from that. You don't want to be raided, right, by way of a search and seizure, and you certainly don't want to be charged as well. But that's where it can get quite dire. So if A, B, or C employee has a discussion with the general counsel, says, hey, I had this discussion and you know, I'm feeling kind of uncomfortable with it now, or somehow the legal counsel becomes aware of such a discussion, that might in the end lead to a discussion with someone like me about, do I go and seek immunity? Do I go see if there's a marker available for that immunity? And that's where you can get risk. So you can have people participating in something like this. It may seem covert, but if one or more of the entities starts moving forward and thinking this isn't right and I should probably do something about it, that in turn can lead to all sorts of consequences for everyone who participated.
Great. The next slide is our hypothetical number 2. So, you know, can we gather market intel from sources other than other employees? So everyone jump in there while we start this discussion. Let us know what you think. You know, one example is, what happens when employees come to you and say, oh, they've heard from other friends that, you know, this is what people are earning. I mean, this is pretty common in the law firm industry, where associates will talk amongst themselves about sort of, you know, salaries and stuff. So what happens if that information comes to you?
So let's see if we can make it 2 for 2. I will say, as you both were speaking, lots of thumbs down, lots of bad, not appropriate on the last scenario. And on this scenario, just waiting for, we've got some thumbs down so far. But not many. Maybe, oh, a thumb up too. So we've got split decisions on this one so far.
So Tony, how worried should we be if we're getting intel from our employees that they hear from friends who are at other companies about certain, you know, compensation items that are being provided to them at other competing entities or other unaffiliated industries in the same sort of industry, but not direct competitors?
So I would say that this scenario is a judgment call, but let me sort of let us help you think through the parameters of this. So on one hand, I would be I don't think it would be a surprise for any of you who are attending this that employees do like to be transparent about what others are getting paid and why they should get paid a certain amount, right? No surprise. So I wouldn't say that is in and of itself is a problem. And so if you learn of pricing and if you learn of salary information because one of your employees is telling you that I should be paid X, or just sharing intel with you, those sort of one-offs I wouldn't characterize as particularly problematic, just given how pervasive it is in the nature of an HR relationship between a company and an employee. But where the line gets a bit more uncomfortable is where it's a pattern whereby perhaps an employer is encouraging an employee to collect such information and does so at a bit of a systematic level, such that they have a very good understanding of what others are what competing employers are paying. It's so where is that fine line? If you have ad hoc information from time to time based on an individual negotiation that has nothing to do with learning about industry trends elsewhere for the advantage of the employer, then I think that would be fine. And some would say, you know, the fact that you learned that information, you may want to memorialize how you learned that information, namely to that employee as opposed to some other problematic source. On the other hand, if it's becoming a pattern whereby you are collecting information, you have a significant amount of information about another employer's business and pricing practices, that's where it can get a bit uncomfortable. And you know, you certainly don't want to be seen as encouraging employees to collect such information and share it with you on a systematic way.
So this raises a really interesting point, this whole idea of exchange of information. that we had a big debate with Tony when we were discussing these new provisions a few weeks ago. The one that came up in our world is, collective bargaining. We obviously have access as counsel and our clients do to, collective bargaining agreements, collective agreements that, are filed to the ministry and are public. But we also know that, when we do collective bargaining, both on behalf of our clients or if our clients are requesting assistance with respect to bargaining, that they will get some of their competitor collective agreements to sort of assess sort of what those bargaining unit employees are being paid and sort of what their allowances are and premiums are, et cetera. So, Tony, can you comment on your view versus what we think the union's view may be with respect to that exchange of information?
Yeah. So a couple of things there. There is an exemption for collective bargaining in the Competition Act, and various folks might have different interpretations of that, but the interpretation I think that is fair based on the plain wording of the legislation and the interpretations that is the art of collective bargaining is what is exempted, not unions, period, or just the broader scheme of it all. And I think that if you're aware of salaried information, because it's a matter of public record, right, or there's some sort of source by which it's accessed that's publicly available, then that's sort of a good way to justify being aware of it, and it would not amount to an improper sharing of confidential information between entities. So I think that that's certainly something you want to be mindful of, particularly in a public context where you can have collective bargaining that's much more transparent.
Great. So hopefully, Scott, that answers your question, because we've had a lot of debate over, how the union will kind of interpret this. They believe that, everything's covered and they can kind of use that exemption, but we still want to be careful about where the source of that information is coming from.
Now, Tony, if I could just do a follow on there quickly. Same thing, would you say for, say, government pay transparency, or for those joining us from BC with the new pay transparency laws coming into force in the near future, which will require publishing for certain employers salary bands, expected salary, and making that information public. Same idea, making sure that you're properly documenting where you've got the information from to show that it is not in between unaffiliated entities.
Yes, and of course, I didn't get into the regulated conduct offense in great detail, but if there's some sort of regulation or legislation that's expressly sharing that information or authorizing the sharing of that information, recognizing the sharing is not the offense, it's the agreement, but just by analogy, the fact that that's being made available does provide some comfort that it would not be in contravention of these provisions.
Moving to the next hypothetical, as we have a few minutes left, can our clients conduct or participate in a survey that's conducted by competitors on salaries, bonuses, or other terms of employment, and how do we respond to a survey conducted by a benchmarking firm? So we've spoken a little bit about that sort of third-party neutral party that's their job is to compile and aggregate information on an anonymized basis. Is there any further tips that you have, Tony, in terms of how our clients should respond to those surveys and how they can use those benchmarking data that is provided to them?
Look, I guess my first comment would be, I think you're going to be making greater use of this as a result of these amendments, which is a good thing, in a way. So it's not, I think that we don't want to scare you away from benchmarking. We think is actually important. At the same time, you do want to do a bit of due diligence with respect to ensuring that the information is sufficiently aggregated and anonymized. Like, just keep using those buzzwords. So, because those are the words that the regulators think about in the competition context. And again, ensuring that the firm is doing that in compliance with applicable laws. So you want the agency to be talking to someone like me, like a competition expert who's thinking through the implications and how information should be shared so that there isn't any perception of a contravention of the law.
And in a way, what you said is actually right, because if you have more people participating in those anonymized surveys, then you're going to get more data, which is going to help the employers rather than having a few people participating, in which case, maybe there's a way to ascertain who's participating in those surveys or not.
Right. But like normally the surveys are run by third-party agencies, right? They're not run by the employer, because technically speaking, if a competitor was running it, they could use your information for other purposes, right? So by its very nature, you tend to find that the benchmarking services would be independent third parties.
Right. So finally, in hypothetical 4, what about the common agreements with vendors? And I've noticed that there's been a few questions here about subcontractors and the use of subcontractor agreements. So I'm just going to go find that for you quickly in terms of, if you're using subcontract agreements, can you use the ancillary restraints defense in that context as well?
Yeah, I guess I'd say first off is before you even get there, is this a one-way or a two-way, right? If you're simply saying I'm loaning you an employee, but we want a provision you're not going to poach them one way, it doesn't go both ways. That should be enough comfort for the reasons we've already discussed. But adding ancillary restraints considerations to your point, Alex, is helpful too, to say something that you wouldn't enter into this it's a common arrangement, but for that non-solicitation constraint, because you're worried about your own employees being poached. So we can understand that, and I think having sure that that's memorialized as well is added comfort to ensure that you're not seen as contravening the competition.
Great. Thanks, Tony. I see that now 12:01. So we're at our time. I really love how many questions came in. We tried to address as many as we could, both before and during the presentation. But would really like to thank you for joining us today. I'd like to thank Marc and Tony for their assistance today. And as a reminder, please fill in the survey if you haven't already done so. Obviously, our upcoming event list is always growing, and so please visit the Fasken Institute section on our website to register for more events coming your way. And have a great afternoon. Thanks again for attending.